All right, that's official. Hello and welcome, everyone. Today we're going to do our second of our spring semester roundtables, and we welcome Kyle DeLand. Kyle is a legal historian of the American colonization of the Pacific in the 19th century. He is a Ph.D. candidate in the jurisprudence and social policy program at Berkeley Law and the Arthur J. Quinn Memorial Fellow at the Bancroft Library. I've said that many times and I still can't ever remember it properly. Over the past several years, Kyle has done research in a variety of Bancroft collections for his dissertation titled Land Monopoly, Property Law, and the Crisis of California Settler Society, 1841 to 1880. Originally from New Hampshire, Kyle and his wife, Aaliyah, live in Oakland with their 3 pets/research assistants, Mango, Tito, and Lila. When not writing history, Kyle spends his time cycling, walking his dog, and playing Dungeons and Dragons. With that, let's welcome Kyle, and it's all yours, Kyle.
Oh, awesome. Thank you for the wonderful introduction. And thank you everybody for coming. Hopefully it'll be a solid use of everyone's time. So the title of this talk is The Land Providence Made. And the background of this, which is just kind of coming up dark on my screen. I don't know if you can see it. It's a picture that I took. It says stolen land, which someone, not me, has been spray painting on the sidewalks around where I live. So just, I think that's interesting. Keep it in your mind. So this talk is basically going to be about a single Supreme Court case, building up to it, that resolves around the question, what creates property in lands? And the close relative of that question, who owns this land, X land? And this picture you see is part of the land in dispute in this Supreme Court case, which is called Frisbee v. Whitney. And at stake are 2 ideas about property law. One, which will be quite familiar, and one which you will think, wow, some 19th century people came up with that. And we'll start with that one. So the first one is a sort of natural law. This is the handsome visage of John Locke. And there are various sources of this. There are various sources, right? There's Locke. A lot of people are deriving their ideas about property and what creates property from the Bible. And there's quite a lot of talk during the American colonization of California of it being divinely promised. There's comparisons with the Exodus story and the land law in Leviticus. There's lots of talk about Providence. And they're kind of, in addition to that, there's a lot of talk about racial destiny. This is an explicitly white supremacist project of colonization. And for these people, they think, hey, that's a good a justification as any for creating property, taking someone else's property. And kind of point 3, sorry, I'm not really working through these point by point, is Locke's idea that property is created by labor, by people using land and improving it, appropriating it from the commons to themselves, that they're putting work into it and making it theirs. So this is sort of a team A, if you will. This is a natural law team in this Supreme Court dispute we're going to have. Team B is, maybe the more familiar team, where, okay, what makes property law? Well, we have some laws about it. We've wrote them down, and there are courts and attorneys, and you can buy property from people, and you have lovely pieces of paper that say this is a deed, and that's how property works. Hopefully that's a familiar idea, right? The people on team A think don't think a lot about that. Don't think a lot of this, as I'll get to in a moment. So these are kind of the two things to keep in your head, two kind of separate ideas about property. I'm not gonna, you could read this. This is the for the legal historians in the crowd. Basically, the idea of this slide is two meanings of property law will enter the Supreme Court case Frisbee v. Whitney, but only one will leave. Natural law, property law are going to head in, and I don't know if I should make suspense, but natural law loses, as you might expect by, people aren't generally making those arguments anymore. And so they're not compatible. There's in American property law during this period. About to talk about the 1840s in particular. These two things are working side by side, and they don't always work together. That's if you're persuaded or not, that's what I'm going to try and this is the story. So the plan, right? The plan for the colonization of California sort of begins around 1841. There's absolutely no legal justification for this that the Americans put forward, like they do in Oregon, right? There's a legal fight about who owns Oregon, which we'll talk about in a second. But the 1840s project of colonization is in some ways utopian. If you ask utopian for who, that's a very good question. But the goal of it is to create a society that's different from the Atlantic states. And for these people, their kind of touchstone law that is more important symbolically and politically than in sort of a literal sense are the Preemption Laws, which basically work, the normal functioning of the government selling public lands at this time was the government sent out surveyors and they made maps and they said, okay, we'll have this public auction where the person that bids the most money will own the land, and then the proceeds will fund the government. Pretty straightforward. The preemption laws come about because American colonists are not particularly patient and aren't going to sit around waiting for government surveyors. And they just kind of go and they're like, this is my land now. And the government did not want to keep evicting them and maybe couldn't have kept evicting them. So they formalized it in law to say, okay, if you're a white citizen, head of household, you can go onto some public domain land and up to 160 acres of it. And you can, if you build a farm, if you live on it for a year, you can buy that cheap before you have a priority purchase to buy that before others. This is especially important for propertyless Americans, right? If you don't own property in New York, hey, maybe you could become a property owner in Oregon. So this is sort of one of the foundational natural law ideas. This is coming out of a time in the 1840s, especially in New York, where there's a big blow up conflict about people who own a lot of land, right? Landlords, right? And there's a discourse that begins circulating. This is a guy called George Henry Evans, who had a political organization whose slogan was "Vote yourself a farm." And the idea was, hey, this is a democracy. You have it in your power to give everyone land, right? And so he has this he says land monopoly is when, anyone holds property on which more might could subsist, as long as anyone, is without, right? So this is a colonization as a social policy to ensure that every white citizen of the United States owns land. Okay, so that's moving so far. The other, I don't know how long I'm going to spend on this slide. I kind of like it. Fellow New Hampshire, Hampshireite of 200 years ago. There's also the religious element, right? This is based in the critics of land monopoly draw a lot of their criticisms from the Bible. And Hall J. Kelly, one of his contributions to the colonization of Oregon was really infusing it with a Christian message. And here we have his fever-induced vision of God speaking to him and declaring that this land belongs to civilization. Like I said, we're going to roll through. So these are kind of, think about these as like a family of people who are influential in thinking through these natural law ideas. Here is another fellow, and this is from an item in the Bancroft Library archives that is a settler guide. So settler guides were books written for potential colonists, and they provided advice. Some are what shirts you should pack, some are what routes you should take. A particularly famous one from this period led directly to the Donner Party disaster, because they said, hey, I know a shortcut, right? So you have these pieces of advice that go out, and this guy writes one. And you all can read here where he says, hey, the government is out here with their Preemption Act and saying, hey, you go to Oregon, we'll give you some land. If you go to Oregon, we'll give you a little bit of land. If you go to Oregon, we'll get a little bit of land. This is meant to be a little bit ironic by the time he writes this, because there's a footnote that says, by the way, the federal government has not recognized my land claim. So already you see there's a little bit of tension. Okay. Next slide. There's another tension, which which perhaps has popped into your head, which is that people live here, right? There are native Oregonians and native Californians, and there are hundreds of thousands of them in this period, and they live there. This is not some empty place where we can all just go get a farm. And there are some people who know this. This is a editorial about Oregon colonization from 1846, where the author is kind of poking fun at Americans, the American and British governments, and saying, which one of us owns Oregon? And this author says, well, maybe the people that live there already. And I do like the quote, anyone but a rogue or an idiot would say that it should be the people in possession, but no, right? So the official policy, the but no is important because the official policy of the United States is that this is terra nullius. Nobody lives here. And that's kind of important for these kind of utopian plans, right? If people live here, that's kind of a wrench in your plan to take all this land and divide it evenly to every white immigrant. Last slide of the natural law section. These people hate lawyers. Quite a few of them are lawyers, and they hate lawyers. They think lawyers are part of this problem. That, look, if we go to California, the lawyers won't be there for a while, this author is talking about civilizational diseases, lawyers among them with smallpox, lawyers, not favorably compared to smallpox in this, right? So that's a long Anglo-American colonization idea of, what if we went somewhere where lawyers were not there controlling property? So natural law is kind of setting itself up as a utopian project. It's based on racial destiny, religious destiny, kind of fairness, like who should own this land. There's an egalitarian project. Some of them identify it as clearly socialist in the 1840 sense of that word. Some of them are not thinking very hard about what they're doing. And so that's the natural law side here, which is, hey, we're going to show up, everything's going to be equal. And they make, quite frequently in these settler guides, they make an interesting claim, which is that California has no laws, which is obviously untrue, but they say it anyway, right? They say, and what they mean is no laws worth respecting, right? They don't think very highly of the Mexican legal system. And we'll talk in a moment of, you can imagine what they think of native claims to land and title. And with the gold rush, these sort of natural law thinkers, they lose control, whatever control they had over this, they lose, because the gold rush brings thousands of people who are not bought into this original thing that they were doing here. And a lot of lawyers show up. And when the lawyers show up, they start to find the laws that were obviously there. This is Henry Halleck of later in charge of the Civil War fame. And he said, hey, these land laws are pretty clear. And it was going fine until a bunch of Americans showed up and conquered the country and declared that there were no laws worth respecting. So here is team two. Here is team, we are lawyers, we have law degrees, and we can assure you there's such a thing as property law. Okay, so this next slide, we're introducing the first character in this actual dispute that leading up to the Supreme Court. I don't know how I'm doing on time. This is probably going way too slow. I should speed it up. So American preemption laws are 160 acres. That's the imagination of Americans. They're like, oh boy, 160 acres is all a family needs. 320, like, ooh, pushing it. Those people are greedy. The Mexican government pursued significantly larger grants to private individuals in the 100,000 acre direction. And this is not popular. This is not popular with people who think that land should be possessed in units of 160 acres. This is exactly sort of land monopolization that they were leaving, New York and other places to escape. And so kind of our team A people look at these grants to Mariano Guadalupe Vallejo, and they declare that they are fraudulent. Whereas the people with the law degrees who show up are like, no, this checks out. Like we have to recognize Mexican law. That is a principle of international law. And so the dispute that we're going to talk about is to Susquel Rancho, which is this kind of 100,000 acre tract. And Vallejo owns this land. His brothers got some land of a similar extent. And here are the maps showing the basis of that land. which there's a few things we can tell from the maps. They're not particularly bothered about the details because they were not expecting to be invaded by a bunch of Americans. And they said, look, here's this land, Vallejo family. There are some native people who live on it. Here's this map. Go figure it out. Go do colonization for us and build some kind of engage in plantation style agriculture with use of unfree native labor. And that's kind of the plan, right? That's what they're up to. And on this map, the map is very much like nobody from Mexico lives here. Like, here you go. There are some people there. And the people there, despite the claims that California has no law, have a perfectly good understanding of property. They have a perfectly good understanding of what is theirs and what is someone else's and what is owed to people when you use someone else's land. Right, the name of one of the estates, La Piomi, is ostensibly, this was in the court case, a place called Town of Stones by the Pomo peoples around it, right? So this is a populated place. This was a part of California heavily impacted by the smallpox epidemic of the 1830s. And so, society is disrupted and many people are dying. But it's not true that the native people, the Mexicans, don't have any understanding of property. Okay. So we've got natural law, positive law. Sometimes they call it kind of human law. We've got this idea that nobody lives there, and that's really important. And it's obviously not true. And so what we have is a kind of utopian project of colonization, encountering facts in the world that are not fitting with that vision. And things are about to get a little violent. I'm not going to sort of glory in it or do too much description, but it's not great. This is not a happy story. So California, American policy towards Indigenous Californians is genocidal, or what we would now call genocidal. They call it extermination generally. And this has a number of reasons for it. Indian removal was the policy of the federal government. It becomes discredited by this time. And so these people are kind of casting about for some sort of idea. And the ideas they come up with at the time, because they're 19th century Americans, are we could enslave these people, or they could just happen to disappear. We could wage war on them until they're not a problem. And natural law kind of serves to justify this, right? Their justification for why American colonists should have this land is that the native Californians aren't using it. They're not developing it. They don't have civilization, but Americans will. It's a question of value. Like, why are we allowed to do this? Well, we're going to make better use of it. God said, hey, here's this thing, improve it. That's what we're going to do. And there's no like positive law kind of stopping this from happening. You see on the map here, covers, right, Susquehanna Rancho, La Piomi, and is kind of has the native language groups and traditional tribal areas that they overlap with, including the Pomo who've come up already. Okay. So back to what they're doing with this land. So Salvador Vallejo leases out his rancho to some American colonists. And the American colonists treat the local population, who again, there are hundreds of, as slaves. And it is an incredibly brutal kind of slavery where the people are treated as entirely disposable. And there's torture, sexual violence, there's all sorts of it's grisly. And so when 5 enslaved men murder these people, they're, on the one hand, that seems to be what these people deserved. And also it was a deadly decision to make, because the lives of these colonists were protected by the U.S. Army, and the U.S. Army sent a detachment of dragoons to go on a punitive expedition. And it resulted in one of the worst massacres of indigenous people in U.S. history. And that is where we get our first named plaintiff in Frisbee versus Whitney, John Frisbee, who, why is he here? Well, he is a captain in that dragoon force. So he's a perpetrator of mass murder. He writes to the newspapers afterwards and says, hey, this is what happened. The army kind of came in and said, hey, could you not tell the truth about what happened? And he said, sure. He retracted his statement. But based on his subsequent actions, we know he was up to something else, right? Which was, as he's traveling through these big estates, he's looking around and saying, this sure seems like a great business opportunity. And he ends up marrying Don Guadalupe's daughter, and he, as a wedding gift, he gets all this land. So he's now the owner of Susquehanna Ranch. So it's a quick year turnaround between punitive expedition to now he owns all this land. So this is Frisbee of Frisbee versus Whitney. In the 50s, this is not popular. Having these large landholders with unfree labor populations, holding the land for speculation, not developing it is incredibly politically unpopular with the people who said, hey, this is going to be an egalitarian colony. And lawyers and politicians respond to that. I don't know how I'm doing on time, but I'll try to keep going. Where Buchanan's attorney general finally says, okay, enough's enough. There's all sorts of litigation that I'm glossing right now over these Mexican grants. But eventually the government says, we're just going to tear a bunch of these up. Here's some money, go to Mexico, figure out which ones of them are fraudulent, and we'll ram it through the Supreme Court. And they do, including to Susquehanna Rancho. So Susquehanna Rancho, owned by Frisbee for a decade by the time this decision is made, he sells it. He gives it, right? He's giving land away according to the land law of the United States. The Supreme Court rules that it never existed. They say it's fraudulent. Like, we can't find the specific piece of paper that we were supposed to have for this. And every single person who got land from Frisbee has, I can do about 10 more minutes. Got it. Well, we'll see if I'll do my best. Thank you for keeping me honest. And presumably this was a huge win for the team natural law, right? Because team natural law, this has just became public land. They can, and they do, walk on in, say, this is mine. It used to be yours. Now it's mine. Build a house and dare people to kick them off. Justice Greer is not about it. And that's important because of what happens 8 years later. Okay, so they say, this is crap, but you don't own this land. This is valuable land. It's worth like $50 an acre because of its wheat production. And with a little bit of understatement, the Marysville Daily Appeal says that Vallejo versus United States it's a problem. This is not great for business. And the former, Frisbee and Frisbee's people do all sorts of chicanery. They get Congress to pass some laws. They kind of fraudulently use other land laws to kind of repaper over all this land to keep it in their own hands. And at the same time that they are acting, we get our other named plaintiff, my co-author. I don't know if that's being picked up on the mic. My co-author's one. Where you get a bunch of dozens of families show up on this ranch, and they say, okay, built a house, like I'm ready to preempt this land. This is mine now. And violence ensues. Not on the scale of violence directed at the native occupants of this land, but it's substantial, right? They call out the army again. These people they put in the newspaper, hey, we are not secessionists, we swear, because this is smack dab in the middle of the Civil War, where I should say US v. Vallejo was decided during the Civil War, so maybe they weren't totally thinking it through. Anyway, so Whitney is one of these squatters, settlers, basically, who showed up on this land and said, it's mine. We'll see if she stops barking. So Frisbee v. Whitney is this case where the Supreme Court says, oops, and there's all sorts of litigation that I'm glossing. Read the book. Where Justice Miller kind of comes out with this statement that, measured against the history of property law and American colonization, doesn't fully check out, which is, look, showing up and building something is not any kind of right to land at all. That's not, what are we running here? Is this a joke? The California equivalent even goes so far as to say, hey, like, this Frisbee guy is really cool. We can't take his property away. Like, that's ridiculous. So they reverse themselves. They say the Supreme Court of 8 years ago were wrong. They don't say that. They pretend that it, didn't happen. And they kind of, all these people get kicked off, right? And some of these ejectments are violent and it's not great. And Frisbee says, okay, awesome. Now that I have a clear title to this land, I am going to hook up with some of the biggest capitalists in the state to make it a money-winning operation here. So Frisbee versus Whitney is the end of kind of this natural law period where you have in the 1840s and the 1850s, this driving logic of American colonization. And you have sort of the death knell of it, right? There's a great quote in the Sacramento Daily Union about this, which is, the Preemption Laws' obvious purpose is to settle the country, not to disturb settlements, right? It's perfectly legitimate to take native land by saying, okay, I'll use it better. Absolutely cannot be done if you're taking a large white landholder's land, right? That's not cool, right? You can't use this law to redistribute this way. And this is the last slide. Hopefully I haven't totally overstayed my welcome, which is just a kind of a summary, right? So this is just kind of one story in the dissertation. Bancroft has a bunch of papers on Susquehanna and the Vallejo Land and Improvement Company. It's just one story. But I hope it's interesting. And this kind of relationship between, right, how unequal can a democracy be? What is the purpose of property law in a democracy? Right, what is the fate of this utopian plan? That kind of remains a live issue. And boom, I probably should stop talking so people can ask questions. Hopefully that was interesting. Thank you for listening, and I'll turn it back over to our hosts.
Thank you, Kyle. That was fantastic. I worked as the curator. I was a translator of the Spanish collection at the Texas General Land Office. Sorry, I'm just returning my mic on. And so there's a lot of similarities between what I, my time as the translator of the land office in Texas. So thank you for that. It's really good work being done on these cases. I'm just quickly in the chat. I'll add a link to all those maps that you, especially the rancho maps that you talked about. Most of those have been digitized, so we can add those to the link here in the chat so that you can all peruse. But I'll open it up now to questions. So you're welcome to raise your hand using the reactions button, or just unmute yourself and ask Kyle a question. Charles?
Yeah, I was wondering how the California land law that was passed by Congress in 1851, how that all fits in. It established a procedure by which the Mexican landowners basically could establish that they had legal title. And it seems to me that in some way or another has to fit into this whole story that you're telling.
Yes, and thank you, Charles, for that question. So that is one of the bigger things that I glossed in my attempt to make a half-hour presentation out of this. Charles is exactly right. The U.S., upon taking over, says, okay, we've got all these Mexican grants, and these are all digitized. In 1851, and they say, okay, we're gonna check these out, right? It's sort of a compromise. There's a faction that says, well, all of these must be illegal, and there's a faction that says, why? Presumably they're all legal. And so they split the difference, and they exact all of them to pretty rigorous scrutiny. On the slide with the fellow with the big bushy eyebrows, those are all like United States versus Vallejo sailed through the Board of Land Commissioners. The Board of Land Commissioners were like, this is cool. The district court that it was appealed to said, this is cool, they own this land. It took like until 1861 when the Supreme Court says, this is fake, get it out of here. They had won every single land case that they had tried, including, as Charles mentioned, the commission. So that's kind of like, with respect to this one story, that's how it kind of fits in. But there are definitely interesting things to talk about with the 1851 commission beyond that. So thank you for if you want to follow up, go for it, but thank you for the question.
Am I right that issues of natural law are still being claimed today? I'm thinking in particular about Cliven Bundy, the rancher who just appropriated hundreds of acres or thousands of acres of public land and refused to pay taxes on it.
Yes, and that is, I think that's a great example. These are inheritors of that tradition. Thank you, Jim, for that. And you could Google that if you want. They've got some interesting ideas about Jews and water rights and all sorts of things. But yeah, that's very similar. And I assume Cliven Bundy doesn't like lawyers either, right? That this is a strain of it kind of becomes right-wing thought. Yeah, but I think that's an excellent contemporary connection. Sorry, I see another hand.
Heiko?
Yeah. So I was thinking of the history of the General Land Office. So that goes back to the Revolutionary War. After the Revolutionary War, the United States was saddled with these large debts and it couldn't repay them. And so, you know, there was a land ordinance of 1785, which established the surveying systems, the public land surveying systems that we know today. And of course, that was a precondition for parceling up the land and selling it to individuals. And there are laws, you know, that kind of regulated that. First, it was disposed in units of 640 acres, that went down to 320, and then it went down to 160, and eventually I think 80. And I think it has to do with Jeffersonian ideas, the yeoman farmer. So there is an egalitarian tradition that's maybe not socialist, but American. So that would be one comment. And the other one, you know, we could kind of use that system as a system that systematically defrauded Native Americans, you know, from the very beginning. You know, this was the business model. And we can see how those revenues were substantial. I mean, they peaked, I think, in the 1830s. I looked at that one time, and it was like 40% of the revenue of the American government came from land sales. It was just amazing. And so I think that I just thought I'd make those two comments.
And the two more wonderful comments. Thank you. Those are yeah, Jeff, I could have talked more about Jeffersonian ideas, and I think the point about the systematic defrauding, which is presumably the motive for whoever's spray painting stolen land around my block, I think it's like it's obvious, but needs to be reckoned with by, I think, the public and by historians too. I think we have time. More question time if people have more questions.
Do you see there being a legal process for that reckoning? Is there a way to sort of, do you see that coming together?
I think property law is a very conservative, it has become very conservative. So what I'll say is, I don't think if to remedy this system, to remedy the injustices of the past, we probably should not rally all the property lawyers, because property law is kind of designed to make sure that doesn't happen. And so that kind of puts it in a pickle, right? Because the story is that property law becomes redistributive. And so how do you justify redistribution? And there's a whole thing about taxes, and that's kind of an 1870s thing. But and on the Native Californians point specifically, there is a Truth and Reconciliation Commission going on right now. I don't know if they will end up speaking to property questions to I don't know. I mean, I don't know if it's just kind of going to be a public facing kind of history kind of deal. I mean, who knows what comes out of that, whether it's just kind of a report, right? I don't know. I don't know if my wife's still here or went back to class, but my wife teaches elementary school. I mean, there's certainly curricular questions about what we teach about American history too. to people. And I mean, I think there's, was walking by on Lake Merritt, there's a shack that is run by the Parks Department. It probably has some equipment in it, but it routinely gets graffitied and then repainted by the Parks Department. And the other day, I didn't take a picture of this, but it said, "This is Ohlone land, wet paint." So I think, there's some kind of like percolating of this in the population. Oh, Jim, thanks for adding that. I will have to look into that. If you want to unmute and tell us more, please do.
Oh, well, it's an organization that strives to not only raise consciousness about how the fact that the land has been essentially never was ceded by the Ohlone, and to make reparations. There's a program where you can look into put in formulas how much of your house and so forth, and pay tax on a voluntary basis to the native people who ultimately could be argued still on the land. But it's a worthy organization.
Chuck?
There was a kind, at least in principle, the government did say that they should compensate Native peoples for their land. And there was a settlement in, I think, 1946 that gave out a few $1 million because they valued the land at a few cents per acre. I believe it only applied to tribes that were recognized, but at least so it obviously didn't begin to be an effective reparations, but it is at least the principle that the government said, yes, we do owe something to these people who had their land stolen.
Thank you. Yeah, and just in the chat, Ramona Collins, one of our colleagues, points out that today is the day one of the listening sessions of the California Truth and Healing Council. And she lists the Tribal Affairs website where you can go in and listen to. And thank you also to Kendra for adding more on the land tax that's on there.
But there are a number of
Yeah.
local institutions, including, for example, the Unitarian Universalist Church of Berkeley, that every meeting or service begins with an acknowledgement of that we are continued to take advantage of land that was never ceded, and we will work to make reparations in some sort.
Fantastic. That's great. Richard?
Yeah, I know there were some land grants that actually made it to Native Americans in Marin, at least. And some were lost shortly after they gained it. But is there any study of how many there were and where they were, and if any still exist from the official land grant, quote, official land grants?
The history of the reservation system in California in the period I study is very messy, because quite often the government says, here's this reservation, and then 3 years later sells it out from under them, or there are American squatters on the land who they say, well, we can't reserve this land because there are American squatters here and they want to get paid, and there's all sorts of chicanery up through, this is historians, my area of expertise extends to 1880. I mean, I think there's almost certainly, as Charles brought up, in 1946, right? There's a history there of what happens after. What are the longer term consequences? It's beyond my personal expertise, but I think it's a great question.
Yeah, and these were private land grants. They weren't reservations. For instance, Nicasio, I believe, was a private land grant to the original native folks who were there. And there's others. I was just curious if you knew of any studies of that.
I have not. No, I think the answer is no. I mean, I could look it up. This is my job, but the answer is
Just
no.
another thing to do, right?
Well,
You know, Richard, I've seen a figure of about a dozen of those, you know, out of what, 600 or 700 land grants. But that's, I can't remember where I saw that figure, but.
And the Spanish law was that as soon as the Native Americans were turned to, quote, people of reason, that the land was theirs, and the missions were simply there for them to be turned into their parish churches. And I guess what happened was Vallejo got in control of the secularization, and he had a lot of cronies and friends, and couldn't help but give most of it to them. But I go ahead, Chuck.
Virtually all the land grants were done during the Mexican period, and the Mexican law was different than the Spanish law. The new Mexican Constitution was sort of based on 19th century liberal beliefs and stuff. So that idea that the land, you know, it changed very much the legal definition of who owned what land. During the Spanish period, in theory, even the Franciscan order didn't really own that land, that they were supposed to be holding it in, you know, in sort of trust for the native peoples. But that really changed in the Mexican period.
Can you give a little more detail of how it changed? Does that be okay?
Well, I'm not an expert in this, but I think the Mexican independence, you know, created a kind of 19th century liberal constitution, liberal in the 19th century terminology, that put a lot more emphasis on private wealth and reduced the role of government in, you know, in holding things in trust and that sort of thing. Whereas the Spanish law, going back to, you know, the imperial system and the royal family, all that kind of stuff was based on a whole different concept of law, really. And I think that then establishes the idea during the Mexican period, these land grants are private property. The very few, there were only like 20 land grants given during the Spanish period. It wasn't so much that they were given as private property, the people were given the right to use the land versus the idea that necessarily it was their private property. But during the Mexican period, the land is given out as private property. So, you know, and I think that makes a big difference.
Thanks, Chuck.
yeah, thank you. But I mean, I'm glad there are so many people who are knowledgeable about this stuff here. So that sorry to those who have less background and I glossed a bunch of stuff, but I'm a talker and only had a half hour. So
Kyle, if you have a link to anything you've published, we'd love to make it available and have it out as well. So if you either want to send it to me and I can post it when we post the video, let me know. I'm happy to, you know, because I think this is a very lively and interesting conversation, and I think this is one of those where we love to hear more and see people, have people be engaged. We're coming right up on the hour, so thank you all for coming. This has been really, really fantastic. If there are any other questions, any other comments, let us know. And if not, we hope to see you again next month. We'll have hopefully yet another engaging conversation on this. So thanks again to all of you for being here, and take care.
Thank you. Great talk.
thank you for hosting.
Thank you.